I want to shift focus to the other big story that we are tracking this evening. In a big verdict, the Delhi High Court in the Delhi riot case has granted bail to Pinjra activist Natasha Narwal, Devangana, Kalita and Jamia Millia Islamia student Asif Iqbal Tanha. Nearly a year after they were charged with UAPA Act, the High Court in its verdict also cornered the government in a scathing, in fact, indictment of the government. It said that this is an attempt to stifle democracy. Here is a detailed report on this.
In its anxiety to suppress dissent, in the mind of the state, the line between the constitutionality guaranteed right to protest and terrorist activities seems to be getting somewhat blurred. The scathing words from the Delhi High Court as it granted bail to activist Natasha Narwal in a 2020 Delhi riots case. The court then followed with this ominous declaration. If this mindset gains traction, it would be a sad day for democracy. After over a year in jail, the Delhi High Court on Tuesday granted bail to Pinjra activist Natasha Narwal, Devangana Kalita and Jamia student Asif Iqbal Tanha. They were arrested in May last year under the stringent UAPA law, charged with premeditated conspiracy in the Delhi riots. In May, Natasha Narwal was granted brief bail to cremate her father, Mahavir Narwal, who had passed away from COVID-19 during the second wave. She had surrendered soon after. The arrest of the three has become a rallying point of civil society anger against the jail instead of bail impulse. Putting that precise impulse under its hammer, the Delhi High Court observed, "It is well settled that detention in custody pending completion of trial can cause great hardship to an accused, that it is improper for any court to refuse bail as a mark of disapproval of the past conduct or to refuse bail to a person yet to be convicted only to give him a taste of imprisonment as a lesson." The judgment is a strong one and emphasizes the principle of bail not jail, seen to have been flouted repeatedly in recent times. Even more scathingly, in the Asif Iqbal Tanha judgment, the Delhi High Court observes, upon a closer scrutiny of the submissions made on behalf of the state, we find that the submissions are based upon inferences drawn by the prosecuting agency and not upon factual allegations.
Protest is not terrorism, and even a call for a chakka jam is not equivalent to terrorist activity. That is the gist of the judgment of the Delhi High Court granting bail to the three activists today. The court has also cautioned courts that just because the government has sanctioned prosecution under strict UAPA provisions does not mean that the courts must accept that blindly.
Finally, in a declaration of support for the arrested activists as well as student protesters in general, the High Court observed, "Having given our anxious consideration to this aspect of likelihood of threat and terror, we are of the view that the foundations of our nation stand on surer footing than to be likely to be shaken by a protest, however vicious, organized by a tribe of college students." Natasha Narwal has become the face of the state's crackdown on its perceived enemies. The implications of today's observations by the Delhi High Court could have far-reaching consequences. With Anisha Mathur and Nalini Sharma, Bureau Report, India Today.
All right, so very scathing remarks have been made by the High Court. And this, ladies and gentlemen, at a time, while you are seeing this, this comes at a time when, in fact, this entire UAPA Act dissent has been time and again has come under the scrutiny as far as the High Court is in the various courts are concerned, largely also saying dissent against the government is not against the country. Now, what are the key points which have been made by the Delhi High Court? The court has said the lines between the right to protest, in fact, and terror activity has been blurred by this charge sheet which has been filed as far as the Delhi police. Sad day for the democracy if this mindset gains traction. The court has also said submissions based on the inference, not facts. This is very scathing when it comes to the Delhi police, which has in fact presented all these inference, as per the court, presented them as facts in front of the Delhi High Court. State can't be shaken by students' protests. It is right to protest, and that is something which the High Court seems to have been, in fact, protecting as far as this order, bail order, is concerned. Going across to my colleague Anisha Mathur, our legal correspondent, who is joining us at this moment with more details on this. Anisha, this is not only a scathing indictment as far as the Delhi police's case is concerned, but it has also far-reaching impact on the other Delhi riots case. There are many others, those who are still languishing in the jails pending trial.
Well, yes, Shiv, this judgment is going to have an impact also on the other matters that are going on. Remember, there are several other persons who've been accused whose bail hearings are scheduled later in this month or in the month of July. Now, what is the most important takeaway of this judgment? I will just summarize in about 3 sentences. First of all, that the UAPA cannot be frivolously used, that just because sanction for prosecution has been given by the centre does not mean that the court is bound to accept it. The judiciary must exercise their independent discretion. And thirdly, that protests, even when there are inflammatory statements, does not amount to preparation for a commission of terrorist act. So these 3 are the basic gist of this judgment. And it's not just one judgment, it's 3 separate judgments in Natasha's case, in Devangana's case, and in Asif's case, in all of which the court has said that you have not brought any prima facie evidence that makes it that gives a justification to keep them in jail. Back to you.
Thank you for joining.